Hi friends, I am Dr. Vivek Dubey, Faculty of Environmental Law at School of Law, Dr. Hari Singh Gaur, Vishwavidyalaya, Sagar, Madhya Pradesh. Today's topic of our discussion and learning is all about Environment Protection Act 1986. But before I move ahead to the introduction of this discussion, let me introduce you about what we are going to learn today. Today's lecture is divided into following modules. Module 1st, Introduction. Module 2nd, Premises of the Act. Module 3rd, Scope and Application. Module 4, Powers of the Central Government. Module 5, Penalties and Offences. And the conclusion. So let's start with the introduction of our topic. Today we are going to learn some interesting facts about Environmental Protection Act 1986. But before we start, do you know what the word environment stands for and why we need a law to regulate this? And what happens if there is no law to regulate environment? An answer to all these questions we can understand by analyzing the historical accident of Bhopal gas disaster 1984. This lethal industrial disaster happened in December 1984 in Bhopal, taking the lives of thousands of people and leaving a permanent injury to the environment and atmosphere of that region. Union Carbide Corporation, an American company, has negotiated with the state government of Madhya Pradesh to open its subsidiary company in Bhopal with the name of the Union Carbide Corporation of India. Because there is a severe crisis of foreign direct investment at that time in India, the politicians agree for installation of a fertilizer manufacturing plant without an understanding of what lethal consequences it would have on the environment of Bhopal. Also, Union Carbide Corporation was not getting permission in the other countries to open this plant because of stringent laws on accountability of corporation in that countries compared to the weak laws or almost no law in India. At that time, there is no law in India which fixes the accountability of multinational corporation for its harmful operations against the environment. Later, when the accident happens, for years the victim did not get relief due to absence of laws, as well as the place containing the toxic waste has not been cleaned and restored due to the lack of legal accountability of the Union Carbide Corporation of India. So, we need to have laws to regulate the activities of corporate, industries and individuals in relationship with the environment we live for a safer and green in tomorrow. Friends, the word environment is derived from a French word environner, which means to surround. There is no universally accepted definition of the word environment. It is a very comprehensive term. It includes within its ambit a wide variety of phenomena. It is a dynamic term that may be used to describe a limited area on one hand and the entire planet on the other. The term environment may be perceived in different connotations. And there are numerous definitions of the term as provided by different national and international legal instruments. Generally speaking, environment includes the external conditions, resources, stimuli, etc., with which an organism interacts. The preamble of the United Nations Declaration on Human Environment, adopted in Stockholm in June 1972, states, "Man is both the creature and molders of his environment, which gives him physical substance and affords him the opportunity for intellectual, moral, social and spiritual growth. The environment is clearly at risk from a variety of sources of harm, mostly of human origin. In order to tackle this problem, it is important that we develop strategies for modifying human behavior towards environmentally benign practices and away from environmentally damaging ones. In very broad terms, techniques for modifying human behavior can be thought of as falling into two types: incentives and disincentives. Law is important as it creates a framework within which incentives and disincentives can operate. Law is all pervasive. Other methods for influencing human behavior are to a certain extent voluntary or optional. Education, ethics, peer and family pressure, these all apply in various degrees. Law, on the other hand, cannot easily be avoided. It is axiomatic to the rule of law that law in a society applies equally to everyone at all times. Environmental law addresses the effects of human activity on natural environment. Environmental protection is a practice of protecting the natural environment at individual, organizational or governmental levels for the benefit of the natural environment and humans. Due to the pressure of population and technology, the biophysical environment is being degraded either partly or permanently. This has been recognized and governments have begun placing restraints on activities that cause environmental degradation. Since the 1960s, movement for the protection of environment have created awareness about the various environmental issues. There is no agreement on the extent of environmental impact on human activity, and protection measures are occasionally criticized. Environmental protection is influenced by three interwoven factors: environmental legislation, ethics, and education. Each of these factors plays its part in influencing national level environmental decisions and personal level environmental values and behaviors. For environmental protection to become a reality, it is important for societies to develop each of these areas. The need for protection of environment can easily be understood from the following facts. 1 billion people in the world have no clean water. 2 billion people have inadequate facilities of sanitation. 1.5 billion people, mostly in large cities of newly industrialized countries, breathe air that is dangerously unhealthy, and so on. The human beings as well as animals need clean food and water, and in order to have clean food and water, it is necessary to protect the ecosystem that makes survival possible. If we do not stop pollution, it is sure that the world will come to an end. If we do not stop pollution, it is sure that the world will come to an end. So friends, obvious are the reasons why we need an environmental law for the protection of environment, as it directly affects the behavior of humans and organizations. And therefore, now we are moving towards the very topic, the Environment Protection Act 1986 and its genesis in India. The Environment Protection Act was enacted in the year 1986. It was enacted with the main objective to provide the protection and improvement of environment and for matters connected therewith. The Act is one of the most comprehensive legislations with pretext to protection and improvement of environment. Friends, the Constitution of India also provides for the protection of the environment. For example, Article 48A of the Constitution specifies that the state shall endeavor to protect and improve the environment and to safeguard the forest and wildlife of the country. Also, Article 51A further provides that every citizen shall protect the environment. In the year 1976, 42nd Amendment Act of the Constitution has brought the changes whereby Article 48A and 51A was added to the Constitution of India, which was earlier absent. And it is the Stockholm Declaration attended and addressed by our then Prime Minister Indira Gandhi that we are implicating these international customary laws into our Constitution. Friends, now we had discussed about the Environment Protection Act 1986 in general and the reasons why we need to protect the environment and what the word environment stands for. Now friends, we are going to discuss our next module, that is premises of the Act or legislation. It is now generally accepted that environment is threatened by a wide variety of human activities, ranging from instinctive drive to reproduce its kind to the restless urge of improving the standards of living. Development of technological solutions to this end, the vast amount of waste, both natural and chemical, that these advances produce. Paradoxically, this urge to grow and develop, which was initially uncontrolled, is now widely perceived to be threatening as it results in the depletion of both living and non-living natural resources and life support systems. The air, water, land, living creatures as well as the environment in general is becoming polluted at an alarming rate that needs to be controlled and curbed as soon as possible. The 1986 Act was enacted in this spirit. From time to time, various legislations have been enacted in India for this purpose. However, all legislations prior to the 1986 Act have been specific, relating to precise aspects of environmental pollution. However, the 1986 Act was a general legislation enacted by virtue of Article 253 of the Indian Constitution. Article 253 of the Indian Constitution is a heading legislation for giving effect to the international agreements. The article reads as, notwithstanding anything in the foregoing provisions of this chapter, Parliament has power to make any law for the whole or any part of the territory of India for implementing any treaty, agreement or convention with any other country or countries, or any decision made at any international conference, association or other body of the Constitution. Pursuant to the international obligations of India, India was a signatory to the Stockholm Conference of 1972, where the world community had resolved to protect and enhance the environment. The United Nations Conference on Human Environment, held in Stockholm in June 1972, proclaimed that man is both creator and molder of his environment, which gives him physical sustenance and affords him the opportunity for intellectual, moral, social, and spiritual growth. In the long and tortuous evolution of the human race on this planet, a stage has reached when, through the rapid acceleration of science and technology, man has acquired the power to transform his environment in countless ways and on unprecedented scale. Both aspects of man's environment, the natural and man-made, are essential to his well-being and to the enjoyment of basic human rights, even the right to life itself. While several legislations such as the Water Prevention and Control of Pollution Act 1974 and the Air Prevention and Control of Pollution Act 1981 were enacted after the conference, the need for a general legislation had become increasingly evident. The Environment Protection Act was enacted so as to overcome this deficiency. So friend, in the second module, we had read about the background of the legislation. So this legislation is having a foreign background of the Stockholm Declarations, as you know now, as well as the Bhopal gas tragedy in India. Now friends, as we understood the background of the legislation, we now move to the scope and applicability of the legislation. The Environment Protection Act is applicable to the whole of India, including Jammu and Kashmir. It came into force on November 1986. Now friends, we are going to discuss the interpretation clause that deals with definitions under this. Section 2 of the Environment Protection Act deals with definitions. Some important definitions provided in this section are Section 2A, which defines environment as environment includes water, air and land, and the interrelationship that exists among and between water, air and land and human beings, other living creatures, plants, microorganisms and property. This definition is not exhaustive but an inclusive one. Friends, a very interesting fact about the definition of environment is that in the United States of America there is a National Pollution Control Act 19 169, and in the England there is a Pollution Control Act 1974. Despite these developed countries have a comprehensive legislation on environment, they fail to define the environment word in their legislation. So in India, the definition of environment has been provided by the Indian legislature, which is in a maiden attempt, but it is well appreciated because the technicalities involved in the definition are so much that an attempt to define is really difficult, and to give a universally acceptable definition is almost impossible because of its abstract components of the environment. Now friends, we are going to discuss another definition, that is environmental pollutant. Section 2b defines environmental pollutant, which means any solid, liquid or gaseous substance present in such concentration as may be or tend to be injurious to environment. Friends, this is the definition of environmental pollution. Environmental pollution is defined in section 2c, which means the presence in the environment of any of the environmental pollutant. Is that these definitions are comprehensive to cover the modern concept of pollution? I do not think so, because the noise pollution, which is a result of a vibration, is neither a solid nor a liquid nor a gas. Similarly, the radioactive waste, the traffic and congestion due to urbanization and the density of the population. Now friends, the definition of environmental pollutant and the definition of environmental pollution contained in this legislation does not cover the modern concept of pollution, and thereby several amendments have also been taken place because by virtue of section 6 of the Environmental Protection Act 1986 to cover the modern concepts of pollution. This implies the imbalance in environment. The materials or substances, when after mixing in air, water or land, alters their properties in such manner that the very use of all or any of the air, water and land by man and any other living organism becomes lethal and dangerous for health. Section 2e defines hazardous substance, which means any substance or preparation which by reasons of its chemical or physiochemical properties or handling is liable to cause harm to human beings, other living creatures, plants, microorganism, property or environment. Now friends, after definition, we are now going to discuss the next module, which deals with powers of the central government to take measures to protect and improve environment. According to the provisions of this Act, the central government shall have the power to take all such measures as it deems necessary or expedient for the purpose of protecting and improving the quality of the environment and preventing, controlling and abating environmental pollution. Such measures may include measures with respect to all or any of the following matters, namely A. Coordination of actions by the state governments, officers and other authorities. B. Under this Act or the rules made thereunder or under any other law for the time being in force, which is relatable to the objects of this Act. D. Planning and execution of a nationwide program for the prevention, control and abatement of environmental pollution. E. Laying down standards for the quality of environment in its various aspects. Laying down standards for emission or discharge of environmental pollutants from various sources whatsoever, provided that different standards for emission or discharge may be laid down under this clause from different sources having regard to the quality or composition of the emission or discharge of environmental pollutants from such sources. Restriction of areas in which any industries, operations or processes or class of industries, operations or processes shall not be carried out or shall be carried out subject to certain safeguards. Laying down procedures and safeguards for prevention of accidents which may cause environmental pollution and remedial measures for such accidents. Laying down procedures and safeguards for the handling of hazardous substances, examination of such manufacturing processes, materials and substances as are likely to cause environmental pollution, carrying out and sponsoring investigations and research relating to problems of environmental pollution, inspection of any premises, plant, equipment, machinery, manufacturing or other processes, materials or substances, and giving by order of such directions to such authorities, officers or persons as it may consider necessary to take steps for the prevention, control and abatement of environmental pollution. Establishment or recognition of environmental laboratories and institutes to carry out the functions entrusted to such environmental laboratories and institutes under this Act. Collection and dissemination of information in respect of matters relating to environmental pollution. Preparation of manuals, codes or guides relating to the prevention, control and abatement of environmental pollution. Such other matters as the central government deems necessary or expedient for the purpose of securing the effective implementation of the provisions of this Act. The central government may, if it considers it necessary or expedient so to do for the purpose of this Act, by order published in the official gazette, constitute an authority or authorities by such name or names as may be specified in the order for the purpose of exercising and performing such of the powers and functions, including the power to issue directions under subsection 5 of the central government under this Act, and for taking measures with respect to such of the matters referred to in subsection 2 as may be mentioned in the order, and subject to the supervision and control of the central government. And the provisions of such order, such authority or authorities may exercise and powers or perform the functions or take the measures so mentioned in the order as if such authority or authorities had been empowered by this Act to exercise those powers or perform those functions or take such measures as considerable adverse environment impact has been caused due to degradation of the environment with excessive soil erosion and water and air pollution due to certain development activities. Therefore, it is necessary to protect the environment. This can be achieved only by careful assessment of a project proposed to be located in any area on the basis of an environment impact assessment and environment management plan for the prevention, elimination or mitigation of the adverse impacts right from the inception stage of the project. The central government has passed certain notifications laying down that the expansion or modernization of any existing industry or new projects listed shall not be undertaken in any part of India unless it gets environmental clearance by the central government or the state government. Now friends, we had discussed the powers of the central government in regard to the environmental protection. Now we are going to move to the next module, powers of the court, which deals how the judicial intervention is justified and required in the field of environment protection, without which we cannot stand today what we are looking towards the environment. Friends, judicial activism has developed the environmental jurisprudence, and by looking to the powers of the court, which is not anywhere prohibited by the legislation, we are going now to understand it, how the court help in the environment protection. The Act does not curtail the powers of the Supreme Court. It has from time to time in various matters issued directions and orders to control pollution. Some such important cases pertaining to protection of environment are: first, direction issued to control vehicular pollution in MC Mehta versus Union of India 1998 Supreme Court. In order to control the chaotic traffic conditions and vehicular pollution, the Supreme Court issued the following directions. First, all commercial transport vehicles which are more than 20 years old should be phased out and not permitted to ply in Delhi after October 1998. Second, all such commercial or transport vehicles which are 17 to 19 years old, that is almost 3200 vehicles, shall not be permitted to ply in the National Capital Territory Delhi after 1998. Third, such of the commercial or transport vehicles which are 15 and 16 years old, almost 4962 vehicles, shall not be permitted to ply after December 31st, 1998. The Supreme Court made this order applicable to all commercial or transport vehicles, whether registered in the National Capital Territory of Delhi or outside, but ply in Delhi, which are of more than stipulated age and which do not have any authority to ply in Delhi. Now friends, the second thing which comes as a judgment of the Supreme Court regarding the protection of environment is protection of coastline of India. In this regard, the case is in India Council for Enviro Legal Action versus Union of India. The Supreme Court, in regard to the 600 kilometers long coastline, emphasized that it would be the duty and responsibility of the coastal states and union territories in which the stretch exists to see that the notifications issued declaring the coastal stretches should be properly and duly implemented. Further, the various restrictions on the setting up and expansion of industries, operation of processes, etc. in the regulation zone should be strictly enforced. In the same case, the court enunciated the principle further that the polluter pays. Once the activity carried on is hazardous or inherently dangerous, the person carrying on such activity is liable to make good the loss caused to any other person, irrespective of the fact whether he took reasonable care while carrying on his activity. Under this principle, it is not the role of the government to meet the costs involved in the prevention of such damage or in carrying out remedial action, because the effect of this would be to shift the financial burden of the pollution incident on the taxpayer. The responsibility of repairing the damage is that of the offending industry. Now friends, other cases as we see in this regard is Vellore Citizen Welfare Forum versus Union of India and others. The polluter pays principle as interpreted by the Supreme Court in this case means that the absolute liability for harm to the environment extends not only to compensate the victims of pollution but also the cost of restoring the environmental degradation. Remediation of the damaged environment is part of the process of sustainable development, and as such, polluter is liable to pay the cost to the individual sufferer as well as the cost of reversing the damaged ecology. Another case in this regard is Goa Foundation versus Diksha Holdings Private Limited, where the court observed that with the view to protect the ecological balance in the coastal areas, notifications having been issued by the central government, there ought not to be any violation and prohibited activities should not be allowed to come up within the area declared as CRZ notification, Coastal Regulation Zone notification. The court also emphasized that no activities which would ultimately lead to unscientific and unsustainable development and ecological destruction should be allowed. Some important provisions of this chapter provide that no person carrying on any industry, operation or process shall discharge or emit or permit to be discharged or emitted any environmental pollutant in excess of such standards as may be prescribed. No person shall handle or cause to be handled any hazardous substance except in accordance with such procedure and after complying with such safeguards as may be prescribed. Where the discharge of any environmental pollutant in excess of the prescribed standards occurs or is apprehended to occur due to any accident or other unforeseen act or event, the person responsible for such discharge and the person in charge of the place at which the discharge occurs shall be bound to prevent or mitigate the environmental pollution, and shall also first intimate the fact of such occurrence or apprehension of such occurrence, and second, be bound if called upon to render all assistance On receipt of such information, the authorities or agencies shall cause such remedial measures to be taken as are necessary to prevent or mitigate the environmental pollution. The expenses incurred by any authority or agency may be recovered from the person concerned as arrears of land revenue or of public demand. Now friends, we are going to discuss penalties. Penalties, as section 15 provides for penalties for contravention of the provisions of the Act as well as the rules, orders and directions. Whoever fails to comply with or contravenes any of the provisions, rules, orders or directions of this Act shall be punishable with imprisonment for a term which may extend to 5 years, or with fine which may extend to 1 lakh rupees, or with both. In case the failure or contravention continues, with additional fine which may extend to 5,000 rupees for every day during which such failure or contravention continues. If the failure or contravention continues beyond a period of 1 year after the date of conviction, the offender shall be punishable with imprisonment for a term which may extend to 7 years. Friends, whether the penalties imposed under these sections are adequate enough to deter the polluter, where the companies are earning in crores now? Regarding this, 2014 and 15, there is a bill which is pending, or a draft pending before the Parliament to pass an amendment to these provisions, whereby now the penalties are enhanced to 1 crore of rupees, so that it would be adequate enough to deter the polluter or the big industries or the corporates in this regard, to deter from the activities of environmental pollution. So presently the penalties for these offences are not adequate enough and it should be amended. Offences by companies are dealt with under section 16. Where any offence is committed by a company, every person who at the time of the offence was committed was directly in charge of and was responsible to the company and for the conduct of the business of the company shall be deemed to be guilty of the offence. If he proves that the offence was committed without his knowledge, or that he exercised due diligence to prevent the commission of such offence, he shall not be liable to any punishment. Where the offence has been committed with the consent or connivance of, or is attributable to any neglect on part of any director, manager, secretary or other officer of the company, such person shall be deemed to be guilty of the offence. As per the provisions of section 19 of the Environment Protection Act, no court shall take cognizance of any offence under this Act except on a complaint made by, first, the central government or any authority or officer authorized in this behalf by that government, or second, any person who has given notice of not less than 60 days of the alleged offence and his intention to make a complaint to the central government or the authority or officer authorized. Section 19 is a salutary provision which is popularly called as citizens' standing. It is a remarkable provision in the light of environmental protection that for the first time this legislation provides a right to move to court to any individual who is not even the aggrieved person. Relaxing the rules of locus standi, he can move to the court by giving a notice of 60 days. So this is a very popular provision which we call as the citizen's suit or citizen's standing. Now friends, we move to the next section, section 22. Section 22 provides that no civil court shall have jurisdiction to entertain any suit or proceeding in respect of anything done, action taken or order or direction issued by the central government or any other authority or officer in pursuance of any power conferred under the Act. Friends, as we see, the central government has power to create an authority under this legislation, and therefore in the year 1997 the government has set up an authority called as the National Environment Appellate Authority. The authority is established by virtue of an Act, National Environment Appellate Authority Act 1997, as an independent body to address cases in which environmental clearance granted by the Ministry of Environment are challenged by civil society. Friends, there are two authorities which are set up by the Government of India by passing the legislations, the National Environment Appellate Authority Act 1997 and the National Environment Tribunal Act 1995. Both these authorities are functional, and the National Environment Appellate Authority was set up as an independent body to address cases in which environmental clearances granted by the Ministry of Environment are challenged by civil society. Now friends, both these authorities, the National Environment Tribunal Act 1995, which set up the National Environment Tribunal, and the National Environment Appellate Authority, which comes by the virtue of National Environment Appellate Authority Act 1997, both these authorities are now dissolved and merged, and now the new body which has come up is National Green Tribunal. National Green Tribunal has come up by virtue of Section 3 of National Green Tribunal Act 2010, which now not only repeals these two previous legislations but dissolves the authority as the one single authority now, National Green Tribunal, to adjudicate upon and to hear the matters pertaining to environmental protection. Friends, against the backdrop of the United Nations Conference on the Human Environment held at Stockholm in June 1972, in which India was a participant, the central government enacted this legislation, the Environment Protection Act 1986, with an objective for protection and improvement of the environment and for matters connected therewith. As per this act, the central government shall have the power to take all such measures for the purpose of protecting and improving the quality of the environment and to prevent environmental pollution. Further, the central government shall have power to give directions in writing to any person or officer or any authority for any of the purposes of the Act, including the power to direct the closure, prohibition or regulation of any industry, operation or process. No person carrying on any industry, operation or process shall discharge or emit any environmental pollutant in excess of standards prescribed by the government. Further, persons handling with hazardous substances shall comply with the procedural safeguards as may be prescribed by the authorities. As per the Act, where the discharge of any environmental pollutant in excess of prescribed standard occurs or is apprehended to occur due to any accidental or other unforeseen act or event, the person responsible for such discharge shall be bound to prevent or mitigate the pollutant so caused, as well as intimate the fact of such occurrence to the concerned authorities. The central government or any other officer empowered by the central government shall have the powers to take the samples of air, water, soil or any other substances from any factory, premises, etc. for the purpose of analysis. The said officer shall without delay send the container with the sample to the laboratory established or recognized by central government. The central government has established several environmental laboratories for the purpose of the Environment Protection Act 1986. For the purpose of protecting and improving the quality of the environment and preventing abating environmental pollution, the standards of emission or discharge of environmental pollutants from the industries, operations or processes are specified in Schedule 1 to 4 of the Environment Protection Rules. The central government takes into consideration various factors while prohibiting or restricting the location of industries and carrying on of processes and operations in different areas. Every person carrying on an industry, operation or process requiring consent under the Water Prevention and Control of Pollution Act 1974 or under the Air Prevention and Control of Pollution Act 1981 or both, or authorization under the Hazardous Waste Management and Handling Rules 1989 shall submit an environmental statement for the financial year ending on 31st March in Form 5 to the concerned State Pollution Control Board on or before 13th day of September every year beginning from 1993. So students, hope in this lecture you have got a detailed idea about Environment Protection Act 1986. If you have missed any of lecture in this series or module, you may log on to our website www.cec.nic.in for LOR, frequently asked questions, assignments and many more. I will again meet you in another session with more learning lectures in coming episodes. So till then, keep learning. Thank you.